Florida statute or chapter 921 discusses regarding the aim of sentencing, that being the primary purpose of sentencing is to punish, the secondary purpose is to rehabilitate. The PSI, which has been reviewed and considered, and I understand throughout the arguments that the defense has raised their disagreements. For what it's worth, the PSI in the factual part really just recreates or retypes the complaint affidavit. I don't really put a lot of weight on that. I don't need that because I presided over the entire trial. So I don't put a lot of weight on the factual recitation that was in the PSI. And as we all know, the PSI is not controlling on the court. The probation officer who does the report makes a recommendation, but unlike in juvenile court, where the Department of Juvenile Justice's recommendation is somewhat binding on the court, the DOC recommendation is not, but I did review that. And of course, as I said, I reviewed the defendant's sentencing memorandum, all of the various attachments, and listened to the statements that were made today from Dr. Russell, as well as David, Wes, Tommy, and Eva Benefield. And all I can say is thank you to everyone who took the time to write a letter and share your experiences. A number of them talked about growing up with Ms. Benefield, their interactions with her as they've grown up and growing into adulthood. Thank you for the statements regarding your relationships with Douglas Benefield and how his loss has impacted each of you. So when I look at the bases for the downward departure and I consider all of the facts and evidence that have been presented to me, my ultimate conclusion, Ms. Benefield, is that this is not a downward departure case. So with that said, the sentence of the court will be as follows. I'm going to sentence you to 20 years in Florida State Prison. That's to be followed by 10 years of probation. Upon your release, and the Florida State Prison was, of course, with all credit for time served, you must initially report to the Bradenton Department of Corrections. We'll be able to provide you a map of where that is. Cost of supervision will be a condition of supervision. Based upon the testimony of Dr. Russell today regarding you suffering from and being diagnosed with PTSD, the court is going to order as a condition of your probation that you obtain a mental health evaluation at your expense within 60 days of beginning your probation. You're to complete any recommended treatment, including residential treatment and aftercare if it's recommended, on the first attempt at your expense. You're to provide proof to your probation officer regarding the evaluation, participation in, and completion of that treatment. If it's necessary for your probation officer, you'll sign any waivers or releases that are necessary for them to get the information that they need or speak with your evaluators and treaters. I am going to order the forfeiture of the firearm in this matter, that being the Springfield .45, and I'm ordering that you have given up all rights, title, and interest to the same. I haven't heard anything about restitution at this point. I am going to order restitution. I'll reserve jurisdiction to determine the amount of restitution, the payee or payees, the payment schedule, if any, and other terms and conditions of restitution. I'm also going to reserve jurisdiction on the restitution to determine whether or not to waive or reduce the monthly cost of supervision and or the fees and surcharges that are associated. I'm going to impose the following monetary obligations: the felony adjudication of guilt court costs, $100 cost of prosecution.
$200.
Do you have an affidavit?
I don't have it with me.
I can look.
If you need one, we can get one.
It's required by Florida law.
Just, there's,
If you want to
3,000
continue on,
page.
we'll try and find it.
All right. If an affidavit is for cost of investigation is presented, I'll order $200 to the Marietta County Sheriff's Office. For now, I'm going to make all the legal financial obligations a condition of probation. All right, State, now that you've seen where I'm at with the sentencing, was there anything that you want to do, any further arguments, anything else you want me to consider?
Judge, my only concern would be the mental health evaluation. I would prefer that it not be with Barbara Russell when she's on probation and has to do the mental evaluation.
You don't want what?
You have ordered that the defendant do a mental health evaluation when she gets out on
Correct.
probation, and I would request it be someone other than any of the doctors that were involved in this case. So, not Barbara Russell or Dr. Quintal or Dr. Broder. Those-
Okay. I'm not going to order that. I'll let you pick your mental health professional that you want to see and consult with. Sir, now that I've told you where I'm at, was there anything that I need to explain or clarify?
No, sir. If you would, how long is the period of probation?
It was 10 years. Okay, Ms. Benefield, you have 30 days to appeal the judgment and sentence of, oh, yes, sir.
I make one statement for the record. I object for the record and argue it's an abuse of discretion based on the undisputed facts, not to grant a downward departure.
Oh, yes, sir, absolutely. I think that's generally preserved no matter what, but
I do too, but.
I appreciate your belt.
But the appellate courts like to find non-preservation, so I'm overly careful.
I understood. Belt and suspenders, no problem at all. Yes, sir. So, objection to the abuse of discretion for not granting the downward departure. Noted. All right, Ms. Benefield, you have 30 days to appeal the judgment and sentence of the court. If you can't afford to hire a lawyer, one will be appointed to represent you. Go ahead.
Sorry, I'll just have one thing
Is it regarding appeal?
regarding,
Appeal?
no.
Oh, well, go ahead then.
I was going to ask the court if the court would make arrangements to ensure that Ms. Benefield remains in Manatee County for at least 14 days, if not 30, so that we can tie up all the loose ends in preparation for the appeal.
Okay. I don't know how much pull I have over that. DOC comes gets people when they come get them.
Can I
There's-
suggest that Your Honor set this for a report in perhaps 30 days?
All right, why don't you send me an order directing the sheriff to hold her pending any final hearings or matters? And I'll,
Judge, the most specific thing, we're going to be filing a motion for bond pending appeal, so that's why we're.
keep her there for that.
Yes, so to avoid the necessity of her going back and forth.
Absolutely. So do me a favor, contact Kelly, my JA, get that set. I didn't see it's been filed yet, but get it filed.
It has not, but I will file it tomorrow.
All right, get it filed. Talk with Kelly about getting a hearing date, and then I'll sign an order to hold her until after that date. Absolutely.
Thank you, Judge.
Thanks.
Of course. Okay, for the appellate purposes, what I was going to say is, ma'am, speak with your attorney. You can hire someone if you want, a private attorney for that. If ultimately you are going to seek the services of the public defender, I'll just need a financial affidavit and a motion to appoint. And then once Mr. Taylor completes all of his obligations as trial counsel, we'll get a local PD appointed and then the 10th Circuit PD. All right, ma'am. Thank you very much.